Yes, Devesh.
Okay. Very good afternoon to everyone. I, Mr. Devesh Joshi, a visiting faculty at Department of Law. Hearty welcomes to our today's chief guest, Professor Robert Cunningham, who is joining us from Australia. Our beloved professor and former head of the department, Dr. Rajshri Varadi ma'am. Our coordinator for today's event, Dr. Alka Patil ma'am, and all others who are present here. I extend my grateful welcome to everyone. So now let's rise for the national anthem.
मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Now I will take over. I request my colleague Vindhya Khan to take over the further proceedings. Thank you.
Thank you, Devesh. Greetings, everyone. I, Ms. Vindhya Khan, like to thank Dr. Alka Patil ma'am for giving me this great opportunity to welcome our Honorable Professor Dr. Rashri and Varadi to our event today. Dr. Varadi ma'am currently serves as the in-charge director of the University of Mumbai Law Academy and is a distinguished professor in the Department of Law at the University of Mumbai. Ma'am's dedication to legal education and her impressive academic contributions have made a significant impact on the field of law. Dr. Varhadi ma'am has a remarkable career spanning over 24 years in the Department of Law at the University of Mumbai. Her extensive experience and expertise have been instrumental in shaping the academic landscape. She has also served as a former member of the Maharashtra State Consumer Commission, Mumbai, where she contributed to the protection of consumer rights. Dr. Rashri ma'am's scholarly work is extensive, with numerous research articles published on various legal subjects, including constitutional law, consumer law, environmental law, and human rights. Her research has significantly contributed to the understanding and development of these important areas of law. Furthermore, Dr. Rashri ma'am has successfully organized several national and international seminars and workshops, providing platforms for intellectual exchange and collaboration among legal scholars, practitioners, and students. We are truly fortunate to have such a distinguished scholar and dedicated educator with us today. Please join me in extending a warm welcome to Professor Dr. Rashri and Varhadi. Thank you so much. Welcome, ma'am. Ma'am will virtually felicitate our chief guest.
Sir, accept the flowers virtually. Robert, sir.
So thank you so much for the introduction. Would you like me to start my presentation?
No, we still have some parts.
No problems. No problem. Sorry, I wasn't sure because
yeah. Dr. Swati Rautela, my colleague and professor, head of the Department of Law, University of Mumbai. My another colleague, Dr. Alka Patil, assistant professor of the Department of Law. and other colleagues, Deepali Patil, and especially student volunteers. Vindhya Khan, thank you for such a small introduction and very apt. And Devesh is there. Hi, Devesh. And other interested participants and other professors who have joined this lecture series. First of all, I congratulate Dr. Alka Patil for organizing this online international lecture series. Today's special chief guest, Professor Robert Cunningham. Our hearty welcome to you, sir, who is the Dean and Head of Curtin Law School, Curtin University, Australia. Today, sir will deliver a lecture on the topic of information governance and intellectual property. In 2022 also, sir has been to Mumbai and we were that time also overwhelmed in your presence. Our students liked the way in which you give us training. So still everyone remember you in University of Mumbai. Hearty welcome to you once again, sir. I request you to keep this continuity and long association with Law Department of University of Mumbai. I appreciate efforts of Dr. Swati Rautela and Dr. Alka Patil in organizing this online international lecture series. Thank you, sir. I welcome all other delegates in this online international lecture series. Thank you.
Thank you so much.
I now request Kavita to introduce our today's chief guest, Professor Patrick Terry.
Good afternoon, one and all. It is my honor to introduce Professor Robert Cunningham, who is serving as the Dean and Head of School at Curtin Law School in Australia. He is also the National Law Head of the Digital Finance Cooperative Research Centre and a Director of Australian Pro Bono Centre. In academia, Professor Robert Cunningham's research has centered on examining the connections between law and international trade, ecological sustainability, and information governance. He has authored a significant body of scholarly work, including academic journal articles and books, both independently and collaborative. His publications primarily explore corporate law, intellectual property, and international trade. Please join me in welcoming Professor Robert Cunningham, whose expertise continues to enrich the academic community at Curtin University, Australia. We welcome you, sir.
Thank you. Thank you so much.
I now request Professor Robert Cunningham to deliver his address.
Robert, sir.
Well, thank you so much for your kind introduction.
Yes.
And hopefully you can see my slides there. Can I just double check before I proceed that you can see the slides, just so that if I do refer to them along the way, I'm aware whether or not they can be seen. If you can't see my slides, that's fine. I will just I will proceed just with an oral presentation. Can you see those?
We can see. Yes, we can see
those slides. Okay, well, thank you. Thank you so much. It's a great honor for me to be here, and I remember my visit to the University of Mumbai fondly back in April 2022, and I particularly thank Dr. Alka Patil for his invitation and for the connection that we made during that time. What I propose to do is to talk about information governance and intellectual property from what I call an information environmentalism perspective. And throughout the course of this presentation, I will explain the nature of both information governance and information environmentalism, and how those concepts relate to the broader concept of intellectual property. So one of the ways in which to understand my work, and by the way, you can download Information Environmentalism as a book for free. It's an open access book, so you can find it on the web. And if there's any difficulty finding it, I can send a link to Dr. Alka Patel or one of the other colleagues there at University of Mumbai, and we can share that link around. But often at the beginning of a chapter, you'll see in books what is called an epigraph or a small quote. And one way of understanding my book is to simply read the epigraphs or the short quotes at the beginning of each chapter. And of course, there's 10 or 11 chapters in my book. And the first one of the early quotes is one by Kurt Lewin, which is that there is nothing quite as practical as good theory. And I really like this idea, because we often think about theory and practice as being two separate concepts, but of course they are very much interrelated. And one of the important words in this particular quote is the concept of good. What constitutes good theory? As many of you know, as academic scholars or students seeking to engage with academic ideas, it is sometimes challenging to construct good theory, and it's even more challenging to think about how good theory might be applied in the so-called real world. But that is the excitement of academia, trying to integrate theory and practice. And one really good site in order to look at the intersection between theory and practice, but also the intersection between private and public interests, is through the lens of intellectual property. We can go back to Venice in around 14 or 1500s, where we started to see the emergence of the modern intellectual property scheme beginning to develop. Obviously, if we fast forward to the Statute of Anne in the United Kingdom in around 1709, we start to see further developments of the intellectual property system. And of course, we can fast forward several hundred years to GATT, and then later on into TRIPS and the World Trade Organization, and we start to see the way in which intellectual property has moved from those beginnings in Europe and in a sense been harmonized throughout the world over a significant over the last several centuries. But taking a step back, or in fact consolidating this idea of the intersection between private and public rights, it's always been the purpose of intellectual property to do just that, because there's no point in people creating things, whether that's making art, coming up with innovations, unless those things are shared with the public. And so on the one hand, the intellectual property system is seeking to incentivize or encourage art, creative endeavor, innovation, scientific exploration. But on the other hand, it's also interested in how we might go about sharing those fruits that come from that creative or innovative labor. And what we see throughout the world, regardless of what area we are looking at, is that there is often a way in which the private interest will end up trumping the public interests. And so we need to take conscious steps in order to ensure that the public interest is always looked after and nurtured and maintained, because if we do not do that, then private interests will almost always trump public interests. And I know from the knowledge that I've acquired by visiting India and by further readings that I've done in relation to Indian governance systems, that the public interest remains a very important part of your political economic landscape and of the political economic interests that many of you seek to pursue. But I guess one of the key points that I make in my work is that as we move into the digital age, and as we move deeper into innovations like generative artificial intelligence and otherwise, the public interest can quite easily be left out of the equation because it's much harder to see the negative impacts on the public interest when it comes to some of these sorts of digital innovations. And so much of what I'm going to talk to you about today flows from the book that I referred to earlier, Information Environmentalism, A Governance Framework for Intellectual Property Rights. This was a book published 10 years ago now, but I've sought to continue to develop this work in various ways, which I'll explain as we move through the presentation. But as I indicated, you can find this work as an open access work, and you'll be able to download it for free. And so I encourage you to have a look at that work, along with some of the other works that I'll refer to throughout this presentation. The starting point for information environmentalism is that there is an intersection between the health of the physical world and the health of the information world. So I guess my interest in this area flowed initially from a concern about the physical environment, whether it be biodiversity, whether it be climate change, whether it be the pollution of a river. All of these things were matters that concerned me. And because of that concern, I became interested in the international trade landscape, because clearly there is an intersection between the way in which our global economy operates and the health of the physical environment. So that's how I became initially interested in the role and the work of the World Trade Organization. And I did a master's in international trade law, and through that became increasingly interested not just in the World Trade Organization, but also more specifically in the trade-related intellectual property agreement, which is one of the global agreements that you would be all familiar with that governs intellectual property rights. And the more I learned about intellectual property rights, the more I saw a connection between the various struggles that existed to protect the physical environment and the various struggles related to what we might call the overreach of intellectual property. So if we cast our minds back for a moment to the United Kingdom in the Middle Ages, at that time, a colonisation process, which you'd all be familiar with in India, was intensifying in the United Kingdom, such that the physical commons was increasingly becoming subject to privatisation. And this process has come to be known in the literature as the first enclosure movement. Like many periods of history, it was a period of struggle where wars were fought, people died. If we fast forward from those Middle Ages to, let's say, the end of the 20th century, we can then begin to speak of what we might refer to as a second enclosure movement. And the second enclosure movement really denotes the contemporary colonisation of parts of the information domain. And at the heart of this second enclosure movement is the overreach of intellectual property rights. Many of you in India would be familiar with examples of intellectual property overreach. We could talk, for example, about the ownership of turmeric, but in Australia, we could also talk about the ownership of something called smoke bush, which is a plant that many indigenous people in this country have been using for many thousands of years. Or we could talk more generally about the ownership of human genes, or the ownership of algorithms, or indeed in the academic environment, we're all very well familiar with instances where we cannot access a book or a journal article because the intellectual property system locks us out. But for me, one very important and, in a sense, symbolic example is patent 6,004,596 in the United States of America. And this is essentially a patent for a peanut butter and jelly sandwich. And my point here really is that the concept of ownership can be taken too far. This would be the equivalent of a company saying in India that they now own dal or some sort of chicken madras curry. In other words, something that people eat every day, and all of a sudden a company is now saying, well, we own this particular innovation. The point here is that private ownership can sometimes have the effect of trumping public interests, and we need to be increasingly mindful of that, as I say, as we move into deeper and deeper into the digital age. So in the information environmentalism work, what I've sought to do is to take some aspects of the underpinnings of what has now become environmental law, and I have sought to apply some of those theories, some of the thinking to the information environment. Because if we think of the environment as a whole, whether that be the air that we breathe or the water that we drink, the environment in economic speak is the classic example of a public good. And we all rely upon the environment in order to live. So if you don't believe me, try holding your breath for the next 2 minutes. And I think you'll soon come to realize that you are relying upon the air around you in order to survive. And if we take that concept further, there are many ways in which we all rely upon the environment in order to survive. So there's many ways that we could think about the contemporary environmental movement that really emerged in the 1960s. But what I've done in this slide is to break it down into 4 different analytical frameworks. So if we think about welfare economics, in the first instance, welfare economics is principally concerned with the true costs of production and consumption. If we think about something like the commons, well, this gets us to think about the validity of property rights. When should we privatize property, and when should we leave it in the public domain? The analytical framework of ecology speaks to the importance of diversity and resilience, among other things, because we know that underpinning every healthy ecological system is biodiversity and this concept of resilience. And we could also speak about public choice theory, which is really putting a spotlight on the regulatory effects of political and economic interests and the way in which those interests might influence regulatory frameworks. And when we're thinking about the information environment as a whole, we might think about the information commons, which is at the center of this particular slide, as the equivalent of the environment in the physical world. And so really what I'm interested in my academic work is what happens when we apply the theories that underpin contemporary environmentalism to the domain of information. And so now what I'm going to do is to go through each of the 4 analytical frameworks that I have briefly explored and talk about how we might apply those analytical frameworks to the information environment. And the purpose of this presentation is to then think about how we might come up with holistic ways of regulating the information environment in the future, so that we start to think about things like privacy violation, misinformation as being part of the one picture, rather than being separate issues that need to be tackled independently. So first, if we turn our mind to welfare economics, what welfare economics really reveals is that property rights often tend to hide various costs. And so economists will refer to these costs often as negative externalities. And the point here is that both in the physical world and in the information world, we can see negative externalities playing out. So for example, a negative externality in the physical world might be pollution in the river or polluting the air from a factory like you see on the slide. In the information world, what we might see is the violation of privacy through one of the big data companies like Facebook or Google or equivalent. And if we think about the power that has been accumulated by Google and Apple and Facebook by virtue of owning information, we begin to see that privacy violation can be thought of as a type of information pollution. And so just like pollution in the physical environment, a little bit of privacy violation might not matter so much at first, but as the problem accumulates, we then move towards a critical mass where this becomes not just an individual problem, but a social problem. And that is really where we are beginning to arrive. Beyond costs, welfare economics also reminds us that the economic system relies upon the free flow of information. And so if you imagine the next time that you walked into the supermarket, that you had to pay to find out the price of every item that you wish to purchase, this would not only be an absurd world, it would also be an incredibly inefficient world. Yet this strange example reminds us that the economic system does actually, in fact, rely upon a type of commons in order to function. So in this case, the commons might be the actual price of a product. The idea being that no one can actually own the price and therefore keep that price in confidence or indeed request payment in order to reveal that price. Rather, in order to go into a supermarket and make choices about what you are going to buy and what you're not going to buy, you actually need to have that piece of information, which is the information of price. And so this thought experiment is to ask what would happen if that price was not actually available and you had to purchase or pay money in order to find out the price of each good. That would be a ridiculous economic system. But in many ways, that's the system that we run the risk of moving into if we are not conscious about the sorts of decisions that we might make as we move deeper and deeper into the digital age. And that's because we know that intellectual property rights have a tendency to commodify information by setting up a type of monopoly right. And we know that monopoly rights tend to also lead to distributional costs. So if we think about pharmaceutical companies, do they tend to produce drugs for tropical diseases that might dominate in a country such as India? Or do those pharmaceutical companies tend to spend their resources on drugs for lesser important ailments like balding or the flu? The main point here is that the effect of allocating property rights to information is that the big pharmaceutical companies will often tend to serve the whims of the wealthy rather than the needs of the poor. So that's all I'll say about welfare economics. I'll now move on to the second analytical framework, which is that of the commons. And one way of thinking about the commons is to go back to Roman law and to contrast these two concepts of res communis or res nullius. Sometimes these concepts are associated with the idea of positive community and negative community. But in terms of the old Roman law concept, res communis begins with the idea that resources belong to everyone, and therefore any use of that resource must be for the public benefit. Otherwise, that use is not legitimate. Contrasting res communis with res nullius would say that resources actually belong to no one, and therefore they are unclaimed and for the taking. And of course, that type of thinking or that rationale has often been used in the colonization process, where imperial powers will come along and say, well, that particular piece of land is not owned, so we will therefore take that land and claim it as our own. And of course, that is the history of this particular continent, being Australia, where for many years the doctrine of terra nullius reigned supreme, and terra nullius basically said that this land was never owned. But of course, we know the truth of the matter was that Indigenous people were living on this land for at least 60,000 years prior to English settlement. So the information commons, just like the environment, is a classic public good, and goods can be conceptualized as a site of struggle. And that's how we might think about res communis versus res nullius, as really a tug of war or a struggle or a battle between different concepts. Generally speaking, res communis will benefit the weaker, whereas res nullius will tend to benefit the strong. And I mean, I use those words weak in a particular way, but not to indicate good or bad, but just to make the point that that res communis has tended to be associated with protecting weaker parties, whereas res nullius has tended to operate to benefit those that already have power. So if we are interested in protecting, nurturing, and developing the information commons, and I think that that's something that we should strive to do, then one of the ways in which we might do that is to embed the Roman law concept of res communis, or otherwise referred to as the positive community principle, into various policy prescriptions and into the operation of the law wherever it is possible for us to do that. And so in practice, what this means is that the information commons should only ever be deployed in the name of public benefit. Now, of course, what I've done so far is dichotomize the commons and property and indicate that that we can conceptualize property as either being in the commons or being privately owned, but in reality, property is often a much more complicated picture. And if you look to the slide, you can see a picture of agricultural land. And throughout history, agricultural land has often been used in different ways at different times. So it may be that in one season, the land is used in order to grow wheat or some other grain. And then at other times, that same piece of land might be used to husband animals, sheep or the like. And so the point here is that land or property can be used in different ways and at different times. And that applies both to the physical world, but also to the information world. So, for instance, when it comes to intellectual property, most of you, I think, will be familiar with the idea of fair use, where you may not be able to photocopy, for example, an entire book, but you may be able to photocopy a portion of that book. Now, these sorts of ideas become much less relevant as we move into the digital age, but also as we have further access to open access goods, like the Information Environmentalism book that I was referring to earlier. Once we understand, though, that property is not always an on-off switch, we can then start to think about ways in which, or we can start to think about the benefits that flow from the interaction between private and public property, rather than simply thinking about privatization as being a way of creating efficiency per se. So if we think about how it is that you got to the location that you are right now, many of you probably used a road or a footpath, which we can essentially conceptualize as a type of commons. And it's the intersection between the commons and private property that really leads to many social benefits that we are all familiar with. I'll now turn our attention to the third analytical framework, which is that of ecology. But before I do that, just to recap, welfare economics reminds us that we cannot necessarily rely upon property rights and corresponding markets to fix every problem under the sun. And the same really can be said with respect to the commons. Both welfare economics and the commons as analytical frameworks draw attention to the limitations of property and related markets in order to create an efficient allocation of resources. So if we turn to the third analytical framework of ecology, we can start to ask ourselves, well, what other governance principles might we use to overcome market and regulatory failures? And I think that ecology really provides at least three lessons that we might like to think about. The first is the importance of diversity and resilience within any system. So whether that is an ecosystem or whether it is a cultural or social system, diversity and resilience are critical. The second lesson is that we can think about applying the idea of legal rights to nature. And I know many countries, including India, have played around with the idea of allocating legal rights to nature, whether that's rivers or trees or the air. And we'll discuss that lesson further in a moment. And the third lesson that I think we can draw from ecology is that we can use it as a metaphorical device in relation to things like national parks. So I know, because I've been to places like Kerala, that India has national parks in the same way that Australia does. And what would happen if we apply that concept of a national park that we have in the physical world, and we would apply that to the world of information? What types of things would we put in an information national park? In other words, what sort of things do we think that the public should have access to, and that cannot be traded away by the state or otherwise sold? So turning to the first lesson of diversity and resilience that flows from ecology, most of you will be familiar with Microsoft, and in particular their internet browser, which is referred to as Internet Explorer. And many of you will have also no doubt used Mozilla Firefox when you are browsing the internet. Now, if you have used these programs, you'll know that both programs have a similar functionality. That is, if you're wanting to search the internet, then you can use these web browsers, and essentially they will do the same thing. But the important thing for our purposes is that Internet Explorer was created under a closed software production model, whereas, of course, Firefox was created under an open source software production model. And without going through the details of how these things are created, what I would say is that open source production tends to lead to more diversity whereas closed software model productions tend us towards more homogeneous ways of doing things. The second lesson of ecology is that it gets us to think about allocating rights to intangible things. So in the 1970s, we had a variety of legal scholars such as Christopher Stone starting to ask the question in the United States as to whether the environment itself should have legal rights. And so if we apply this idea to the information environment, perhaps we need to start thinking about how we might apply rights to the information commons. So that is, just as we have allocated private property rights to intellectual property, perhaps we need to think about allocating rights to the information commons in order to protect public interests. So in other words, we allocate intellectual property rights in a way to protect private interests, although there is always a public interest analysis sitting behind that allocation. What would happen if we took the idea of intellectual property rights and we started thinking about information commons rights? So that is rights that were allocated to the information commons that people could make use of in the courts or to otherwise speak in the name of the public interest. So in the same way that we have created environmental laws that allow organizations or people to speak on behalf of rivers or trees or the air, perhaps we also need to start thinking about how we might apply that idea to the information environment so that people can speak on behalf of the public interests relating to the information environment. And so this really brings us to the third lesson of ecology, is how might we use these metaphorical ideas such as an information national park in order to protect certain aspects of the information environment. So to give you a concrete example of what we're talking about here, imagine if someone came along and said, or a company came along and said, I now own the Hindu language. And every time you want to make use of that language, you have to pay a license fee in order to speak that language or to write that language. Of course, this is a ridiculous and absurd idea, but as we move deeper into the digital age, what we find is that it's easier for certain things to be owned by corporations without going through the normal analysis that we might go through in order to make those sorts of allocations. So on the flip side of my example about language, what would happen if we did create informational national parks? What are the sorts of things that we would want to put into this national park in order to ensure that those things were protected? So it might be the human genome, it might be particular types of algorithms that impact upon health or education outcomes. While this idea might seem somewhat fanciful, the legal instrument that underpins Wikipedia and Mozilla Firefox, which is the general public license, actually already moves us in this direction already. So it's not actually a new idea in some ways. So that's all I'm going to say about welfare economics, the commons, and ecology. We now turn our minds to the fourth and last analytical framework, which is that of public choice theory, which is a theory that really says that public decisions will be detrimental when concentrated interests trump the collective as a whole. And so we might think of examples like climate change. If you have various interests that would prefer for climate change to not be part or to not be regulated in particular ways, it might be oil companies that have an interest in seeing certain regulatory impacts or regulatory steps not taken. We then have a situation where the oil companies are having an influence over climate change policy. And of course, we don't need to use our imagination too much to see how might that play out. But public choice theory is not only interested in the way in which concentrated interests will affect regulatory frameworks, it's also interested in how those dynamics might be overcome. And so over the last several decades, we've seen many civil society organizations that have emerged in order to overcome what we might refer to as collective action problems in order to counter the interests of big oil or big coal. And this battle between concentrated interests and civil society organizations has also been playing out in many ways in the information environment. And so one way of conceptualizing the way in which you would apply the public choice theory to the information environment is to think a little bit more deeply about how things are produced in any economy throughout the world. And I have a map here, a political economic map, which, like all maps, is simplistic, but it's really used as a device to tell a story. And so you can see from this map, there's a few things going on, but if we think of it in terms of a compass, then in the north, you have authoritarian or let's call it control. In the south, you have libertarian, or let's call it freedom. In the east, you have inegalitarian or unfairness or inequality. And in the west, you have egalitarian, which is fairness or equality. And so every country around the world adopts a different political economic system. And of course, some countries rely more heavily on state production. Other countries will rely more heavily on market production. But the point is that all countries will essentially locate themselves, or they can be located on this map in terms of the way in which they trade off control and freedom with fairness and unfairness. But the other aspect of this map is the way in which things are produced in an economy. And so we can talk about state production on the one hand, which is in the northwest corner. We can talk about firm production, which is in the northeast. We could talk about market production, which is in the southeast, or we could talk about social production, which is in the southwest. And what I seek to draw out in my academic work is that depending on what you are seeking to produce, will have a determination as to the best way of doing that. So, for example, if you want to manufacture an aeroplane, it's probably best to rely upon a firm. If you want to build a national internet network, then the state is usually pretty effective at building that type of infrastructure. The market works pretty well when producing goods and services where there are low barriers to entry, such as growing fruit and vegetables or providing some other services like massage, for example. But what is of most interest for us, particularly with respect to the information environment, is the concept of social production. And we don't often think about social production as an explicit form of production because much of it happens behind the scenes, and it's often not necessarily conceptualized as a type of production. But if you think about music, if you think about language, if you think about the development of science, even if you think about the development of law, most of this type of production has actually occurred through a social production frame. Now, this map, as I said, is simplistic, and in real life, you will often see hybrid types of production modes. So you might see the firm teaming up with the state and producing things in that way. Sometimes there's blurry lines between what might be conceptualized as market production on the one hand and what might be perceived as firm production on the other. But the point is that there are different types of ways of producing things, and and we need to be aware and conscious of these different production modes, particularly as we move deeper into the digital age, so that we can understand the role of the different extremities of this map. So where are we going to sit in terms of control and freedom? Where are we going to sit in terms of fairness and unfairness as we move forward in our respective political economic systems? And so when applying some of these ideas around production modes and thinking more deeply about how we might apply public choice theory to the information environment, it becomes clear that in the 21st century, a key challenge is to ensure there is a competitive tension in the production marketplace. So if we go back a few hundred years, thinking about the ways in which many of our constitutions are developed, including the constitution in India, a key idea really flows from Montesquieu back in the 1700s with his classic The Spirit of Laws, which essentially provided the foundation for this idea of separating political power. So this is why we have sought to separate the decision-making of government, for example, with the decision-making in the judiciary, and why it's so important to have an independent judiciary, because we actually want political power and judicial power to have some level of separation, in recognition that absolute power corrupts absolutely. But the problem is that while Montesquieu's ideas of separating political power have been important, and they've been embedded, as I said, into many constitutions around the world, what we've seen over the last few hundred years is that power has shifted away from the political domain and towards the economic domain. And that is why we need to be just as concerned with separating economic power as we do with separating political power. And so in my work, I talk about the separation of economic power doctrine. And the best way of enacting this doctrine is to ensure the competitive tension between the state, the firm, the market, and society when it comes to the realm of economic production. And in the 21st century, most social production is reliant upon the information commons. And so if we deplete the information commons, then we diminish the production marketplace. And in turn, we undermine the competitive tension between the production modes. So I know that what I've talked about is quite complicated, and what I've tried to do is to essentially summarize some of the key principles that we might rely upon if we were to take some of the ideas that I've talked about seriously. And so this is very much coming at it from a principles point of view, thinking about when we are creating law that will affect the way in which information is regulated, we should take these sorts of principles into account, drawing upon the four analytical frameworks which I have been referring to. That is welfare economics, the commons, ecology, and public choice theory. All of these analytical frameworks provide lessons or principles that we can then draw upon in order to think about how to regulate information from a more holistic and integrated perspective. So what I've tried to do with my work since publishing Information Environmentalism is to engage in a number of thought experiments about what the future of information regulation might look like. And one way that I've sought to do that is to engage in what I've started to call legal science fiction. And so that is dreaming up factual scenarios that might occur in the future, and then start to think about how we might how courts or the judicial system might interact with those factual scenarios based on the history of law. And so the book that I have up there on the slide is one example of a publication that seeks to play around with some of these ideas in relation to legal science fiction, where either current judgments have been rewritten or future judgments have been established in order to improve the legal imagination of where we might be moving in the future. And so in the book that I just mentioned, I have basically talked about a case that is handed down by the Australian High Court in 2037. So this is about 15 years from now. And what I've tried to do is to think about the sorts of intellectual property struggles or the sorts of struggles that might play out in the information environment as we move forward. Now, given the time constraints, I won't try and go through the particular facts that I've dreamed up, nor the particular judgment that I have created in order to interact with these facts. But I really wanted to make the point that the purpose, in my view, of academic work is, one, to lament the dark and to draw attention to some of the problems that one might see as an academic. But perhaps more importantly, I think academics are also gifted with the opportunity of lighting candles. That is, providing hope or providing guidance as to how we might move as we progress into the future. And so that's why I think the idea of writing judgments in the future is going to be particularly important, because it exercises our imagination and gets us to start thinking about the sorts of problems that we might have to confront in the future, but perhaps more importantly, how the law might seek to engage with those issues. One of the ideas that I've come up with in relation to the particular future judgment that I have referred to is to come up with some hypothetical legislation. So I've talked a little bit about the idea of the information commons and the idea that we might allocate rights to the information commons so that we can ensure that the public interest is protected in the information domain. And so you'll see up there on the slide the idea of an Information Commons Rights Act of 2029, which is, of course, 5 years in the future, that could then be used as an instrument in order to protect the public interests in the information environment. And so part of that story is the legal concept of locus standi, sometimes referred to simply as standing, which is to say that third parties or civil society organisations could go to court and to speak on behalf of the information commons or the public interest aspect of the information environment, in the same way that even old Roman law concepts like public trust doctrine have been used in order to speak for the physical environment. So I'm not sure if you are familiar in India with the public trust doctrine, but it has become quite important, principally in the United States, with respect to environmental legal battles. To a lesser extent here in Australia, it is occasionally used, if not more conceptually rather than practically. But the central idea behind the public trust doctrine is that there are certain things that the public should have access to, and the state is prevented from trading those things away in order to, let's say, sell a public lake into private interests. The public trust doctrine would create limitations on the ability of the state to move down those particular pathways. And so what I'm saying is that we can start to think about how we might rely upon these sorts of doctrines in the information environment in order to protect the public interest. And so this is just a quote from the hypothetical judgment, which I've created, which, as I said, is based in 2037, so in the future. But it says in this hypothetical judgment that access to and use of biological data, which is inherent within the information commons, is a fundamental human right that cannot be traded away by the state. And that is really just a simple, that is a simple way of articulating the way in which the public trust doctrine might operate, both in the future, but also with respect to the information environment. So there's a lot more that I could say, but I thought that I'd provide the opportunity for some questions, or if there's any issues that you'd like me to discuss further, then I'm perfectly happy to do that. But I've also provided some further reading there. You can access most of this work on the web for free, and that goes not just for the journal articles, but also to some of the books that I've mentioned along the way. So just by summary, where have we gone? What I've tried to do is to give you a roadmap of this work of information environmentalism, to give you a springboard to start thinking about how we might interact with the public interest when it comes to the information environment. What I've done in my work is to rely upon the analytical frameworks that underpin the contemporary environmental movement, but perhaps more specifically, these ideas around welfare economics, the commons, ecology, and public choice theory all fed into the evolution of what we now call environmental law. But if we went back to, say, the 1940s or 1950s, there was no such thing as the environmental law. We needed a political movement to emerge, which then drew attention to pollution, to deforestation, to all of the various environmental issues that we are all familiar with. And once we started to see those issues as falling under one umbrella rather than being separate issues, we could then start to develop a regulatory framework that dealt with those issues. And that's, of course, what environmental law began to do. And I guess what I'm saying in my work is that we now need to start taking those same ideas and applying those same ideas to the world of information. And so that we start to see misinformation and privacy violation, which in the first instance might seem separate, but actually they're often part of the one problem. And until we start thinking about regulation in a holistic way, then we will really be dealing with these problems in isolation, when really what we need to do is to be dealing with them in an integrated, holistic way. So I hope that at least some of what I said made sense to you, and that you've got something out of those ideas. And as I said, I'm very open to any questions or comments that you might have. But once again, let me thank you for the opportunity of presenting to your esteemed institution there in the University of Mumbai, the Department of Law, and thank you for all of the colleagues behind the scenes that facilitated the invitation. Thank you so much.
Thank you, sir. Thank you. I would like to take a moment to express our gratitude, sincere gratitude for the enlightening lecture on information environmentalist governance framework, the second and closure movement and public choice theory. Your insights into how these concepts interrelate have actually provided us with a deeper understanding on the complexities involved in information governance and intellectual property. Thank you for sharing your knowledge and for fostering such a stimulating and engaging learning environment. With your due permission, I do have some questions, but I will just take one if you allow us.
Of course, no problems at all.
Okay, so one of our audience have asked that how do emerging technology, that is AI, intellectual, artificial, the thing, blockchains will impact information governance?
Yeah, well, look, that is a very good question. How does generative artificial intelligence and blockchain influence information governance? I mean, what we need to understand about things like generative artificial intelligence is that there is a lot of big capital and big money behind recent innovations in this space. So we often hear the phrase open AI, but open AI is not open at all. Open AI is closed. It's a closed shop, and it's basically being funded by the Elon Musks of the world and others with huge amounts of capital, requiring huge amounts of energy and resources in order to generate the so-called artificial intelligence that is being created. So from my point of view, it goes back to the separation of economic power doctrine, which I was talking about before, and we need to think more deeply about how we as a society organize each other in order to create the sorts of things that we've created in the past. So if we think about language, for example, I think it's a very useful example because we all speak a language. And we have to ask ourselves, how did that language emerge? The language wasn't created by a company or by a government or by the market. The language was created by people interacting with each other and wanting to share with each other and connect with each other. And we sometimes start to think that we need intellectual property rights in order to create things. But that's not the story of human history. Human history has been creating things for many thousands of years without the benefit or so-called benefit of an intellectual property rights system. So how do we take some of those older ideas about creation and production and apply those ideas to the modern world? And that's, of course, what open source software production models have sought to do, for instance. And I know in India, for example, that those models are very strong, and I commend those initiatives. But my point would be that unless we are actually doing these things on a conscious basis, it will be very easy for them to slip away and for big capital or big corporate interests to dominate the future because we don't organize ourselves in an effective manner. And so I think whether it's blockchain technology, whether it's artificial intelligence, the key question is who owns the technology? Who is controlling the technology? And until we actually address those questions, then we can almost guarantee that private interests will end up trumping public interests. And that really is one of the key points of my presentation, is that public interests need to be protected in a conscious way, because if we leave it to others, or we leave it to expectations or hopes, we will generally be disappointed. So we need to be conscious of these things and take ownership and to organize together in order to overcome what is often referred to as the collective action problem, which is the costs associated with doing things together. We have to find ways of overcoming those collective action problems.
Thank you, sir. I would like to thank Rashri ma'am, Alka ma'am, and Swati ma'am to bring Professor Robert on this platform so that we could get good insight of this topic. Thank you, ma'am. Thank you, sir.
Thank you so much, Nidhi Barra.
Now I take this privilege to propose my formal vote of thanks, my sincere gratitude to Dr. Swati Rautela, Head Department of Law, University of Mumbai, Dr. Rajeshri Varadi ma'am, Professor and former Head Department of Law, University of Mumbai, our today's chief guest, Professor Robert, for such enlightenment and such wonderful session on the topic which, sir, you have delivered today. I'm sure all of us have been greatly enriched with the knowledge. My sincere thanks to Dr. Alka Patil, Assistant Professor, who is also the coordinator for this international lecture series, all other faculty members of Department of Law, all the students who have joined this webinar, as well as all the technical staff members for your contribution to make this international webinar very successful. Thank you so much once again.
Thank you, my friends.
With your due permission, Varadi ma'am and Alka ma'am, can we end today's webinar?
Yeah, thank you so much, Mr. Robert, and all of you. And now the link is going to end. Thank you so much, sir.
Thank you.
Thank you so much, and I look forward to visiting Mumbai. Maybe in April next year is one possibility. So perhaps we can be in
sure.
contact.
Please drop mail, sir, accordingly. Yes, sir, please.
Yeah.
Thank you, sir. Thank you.
Thanks again.
Bye. Sir. Yeah, bye, sir.
Thank you.
Okay, I'll sign out now. Thank you so much.
Thank you so much, sir.